Thank you so much. I appreciate all of your testimony, and sorry that I missed some of the opening statements. Let's go right into it now. We'll go back and forth between Republicans and Democrats in order of seniority and arrival, and we'll begin with that now with 5-minute rounds. Commissioner Meador, I'd like to go to you first. How do you think principled and consistent antitrust enforcement can diminish, or in some cases even obviate, the need for prescriptive regulation?
Hey, Patriots, welcome back to the channel where we fight for faith, family, freedom, and the forgotten men and women of this great nation. If you're sick of DC bureaucrats colluding with big business, if you're tired of government red tape killing small-town opportunity, then stick around, because this one's for...
Thank you. It's an excellent question. The two are closely connected. I was thrilled to hear other witnesses highlight this, as well as your remarks and Ranking Member Booker's. When we have robust, strong antitrust enforcement, that's what helps maintain competitive free markets. Regulation is at the opposite end of the spectrum. That typically comes in when there's been a market failure. And one of the purposes of strong antitrust enforcement is to prevent those market failures. And so I think it's critically important that we maintain strong enforcement. You know, we hear about companies today that like to brag, saying that they can move fast and break things. But the FTC will move fast and break things up. And if their conduct harms competition, we will step in, because antitrust enforcement today prevents the need for regulation tomorrow.
Right. And that's often true, especially if what's being broken up is being broken up because it's anti-competitive, rather than because it's big simply as such, or for some other reason. Mr. Alford, your testimony describes an alliance between big government and big business, one that uses the rulemaking process rather deliberately in order to place barriers to entry into that marketplace. In other words, it's one thing if regulations have the incidental effect of creating a moat, an anti-competitive moat around market incumbents. It's quite another thing when that is the design, when it's the feature rather than a bug. What can be done to prevent this sort of thing going forward?
Yeah, thank you for your question. Again, as you suggest, different regulations have different purposes, and I think the kinds of regulations that we should be the most concerned about are the ones where there is agency capture or where there is corporate lobbyists that are simply trying to increase the barriers to entry for other competitors. Often, the scenario in which that happens are large companies, big ag, big tech, big pharma, can raise barriers to entry and accessibility to the market for the lower, small and medium-sized companies. And there's a whole variety of different ways to prevent the problem. It depends if you're asking about going forward to prevent future such regulations or going backward to try to undo some of the previous ones. Our focus has been on trying to undo some of the anti-competitive regulations that have been enacted that fall into that category, where there has been agency capture or laws that are passed because of corporate lobbying. In terms of going forward, obviously, much of the problem should be greater transparency and recognition about the influence of these sorts of lobbying efforts, about what the purpose of the laws are. Very often, if you read between the lines to try to really drill down, they have to make up a reason why this is in the public interest, but it very often is not really a credible argument. I've seen that in numerous occasions. So much of the effort, I think, would be on trying to have regulations, agencies and Congress be sensitive about what's the true purpose of what they're trying to accomplish.
Right. I suppose one approach that one could take, at least prospectively, would be a reform like the REINS Act, which would require Congress, with regard to major rules, to be the ultimate decision-making authority on whether to propose it as new legislation. Article 1, Section 7 certainly tends to contemplate that you can't make or amend federal law without following that process. That would at least allow these considerations to be undertaken. Professor Francis, your testimony highlights some of the problems with licensing, occupational licensing recognition, the barriers that some of those things provide, particularly to military families who, by virtue of their military service, frequently have to move from one place to another. Most of these occupational licensing regimes, of course, are creatures of state law, not federal. So what steps do you think can appropriately be taken at the federal level in order to diminish this problem, either by encouraging states to reduce unnecessary licensing burdens without compromising quality or safety or otherwise?
I think, Mr. Chairman, that's exactly the key question. Everyone recognizes the policy problem. What are we going to do about it? And while it's true that these systems are created by state law, the problem, at least the one we're talking about today, is distinctively a congressional concern. It's the impact on interstate commerce, and specifically the borders that workers and their families, both in and outside of our military, face when they try to exercise that sacred constitutional freedom to enjoy open and competitive interstate labor markets. So with that in mind, I think there's a spectrum. At the mildest end, you could imagine federal incentives that encourage but don't require states to adopt interstate recognition programs, either in specific areas, specific professions, or more generally. Cranking up the intervention a little bit, you could imagine a federally operated but voluntary for states recognition system, perhaps operated by the Department of Labor or the FTC, where individual states can notify the Department of Labor of their intention to participate in the federal program. And by doing so, they get mutual licensing recognition with any other state that chooses to participate. So again, that's the federal government as a facilitator, not as a director. One more notch along the spectrum, you could imagine federal licensing of some professions. Might not want to do that in every case, but across the board, you can see occupations where it wouldn't be crazy to imagine the Department of Labor or perhaps some other branch of the government establishing perfectly reasonable requirements and giving workers the freedom to apply for an interstate federal license, maybe even a federal bar exam, recognizing there are plenty of attorneys in the United States who only practice in federal courts. Finally, at the far end of the spectrum, you could imagine Congress really leaning in to protecting interstate commerce and labor and creating a mandate, creating a federal right to work across state lines that to the extent you've obtained a license in an individual state, that provides you with a federal freedom to work in any state that has equal or lower barriers to entry. That would be a remarkable intervention that would concretely do a lot of good for a lot of people.
Yeah, those are great points. And you've got me thinking. I mean, when you refer to the Commerce Clause interest at stake, there are existing judicial remedies, at least in theory, available for circumstances where a state discriminates either facially or in effect on a product here, a service, based on its origin or destination out of state or outside the United States. Typically, you're going to face a pretty tough battle if it facially discriminates, but you might also face another battle, and there might be a judicial remedy, even in the absence of facial discrimination, if you can show that the putative non-discriminatory benefits are substantially outweighed by a detrimental effect on the ability to deliver that service from across state lines. Now, that judicial remedy tends to be pretty hard to come by. But I think what you're suggesting is that federal legislation building on those could change some of that difficulty in a way that is compatible with federalism.
I couldn't agree more. So I take your first observation to be, wait a minute, don't we have a Supreme Court created, long settled, dormant Commerce Clause doctrine that is supposed to guarantee to every citizen in the United States and every person who's working in the economy the freedom to be free from state level or local protectionism and discrimination? You are exactly right, and I think the failure to recognize licenses at the state border raises serious problems under the Dormant Commerce Clause. That's actually the next academic project that I'm planning to pick up.
Excellent.
But access to litigation isn't a practical option for everybody. These licensing regimes don't just apply to, high-paid doctors and lawyers. We're also talking about an astonishing array of professions. We're talking about plumbers. We're talking about personal trainers. We're talking about landscape gardeners. I'm not sure it's practical to hope in a meaningful way that those folks are all going to be able to litigate their way through to interstate commerce, recognizing also that there has been a pretty striking tradition of judicial skepticism of this Dormant Commerce Clause doctrine in a way that I actually think runs right in the face of the original meaning and expectation of the way the Commerce Clause was going to operate on behalf of American workers. So while I think the Dormant Commerce Clause should be doing exactly this work, That is not the experience on the ground. It's been clear for decades, and that's why I think affirmative congressional leadership would be so valuable here.
Right, well, particularly for poor middle-class Americans. I mean, it's one thing if you represent a large industry group and can afford to litigate these under these difficult-to-litigate standards. But we should look into that. Anyway, thank you for looking into this, and thanks for plugging the Dormant Commerce Clause. In my hometown of Provo, Utah, we speak of little else. Senator Booker.
Mr. Chairman, may I suggest, being that you and I are here for the duration and love nothing more than discussing the Dormant Commerce Clause, that we allow Senator Blumenthal to go first.
Today, I'm reacting to a congressional hearing that tackled some huge issues: antitrust enforcement, regulatory overreach, and the government's silent war on American workers. Let me tell you something. It's worse than you think. Let's kick things off with Commissioner Meadows' statement. She says strong antitrust enforcement is better than regulation because it keeps markets free and competitive. Guess what? She's absolutely right. But here's the kicker. Our government hasn't been doing either. They've let big tech and big pharma become unchecked monsters, while at the same time creating regulations that crush the little guy. This isn't about keeping the playing field fair. This is about rigging the system to protect monopolies while small businesses get left behind. Move fast and break things? That's not innovation. It's destruction when it kills competition and tramples consumers. Next up, Mr. Alfred hits the nail on the head. He talks about the alliance between big business and big government, a cozy relationship where lobbyists write the rules to make sure nobody else can compete. You think Facebook wants competition? You think Pfizer wants a little biotech startup to eat their lunch? Of course not. So what do? They buy influence, they capture agencies, and they build regulatory moats so thick no small business can break through. Let me be crystal clear. This is not capitalism. This is cronyism. And it's everything the founders warned us about. Now, there was a brilliant point raised about the REINS Act, a reform that would require Congress, not unelected bureaucrats, to approve major federal rules. That's how it should be. Article 1, Section 7 of the Constitution says only Congress can make law, not some anonymous rulemaker buried in a 3-letter agency pushing 500-page regulations we never voted for. The administrative state is out of control, folks, and the REINS Act is exactly the kind of common-sense accountability we need to bring it to heel. Then we had Professor Francis drop some truth bombs about occupational licensing, how states make it nearly impossible for workers, especially military families, to move and keep their careers. Let me ask you this. Why should a plumber licensed in Texas have to start over just to work in Arizona? Why should a military spouse have to recertify every time her family is stationed somewhere new? It's insane, and it's another example of how government regulation punishes working-class Americans. It's insane, and it's another example of how government regulation punishes working-class Americans. The elites don't deal with this garbage. It's the electricians, the hairstylists, the truckers, the backbone of this country, who suffer. Francis floats a few ideas for fixing this. Incentives for states to honor each other's licenses, voluntary federal programs, or even federal licenses in some professions. Now listen, I'm not normally a fan of more federal power, but if it's done in a way that protects interstate commerce and gives power back to the people, not bureaucrats, then maybe it's worth a look. We need to protect workers' rights to move and earn a living without government permission slips at every state line. They also brought up the Dormant Commerce Clause, a legal doctrine meant to stop states from discriminating against out-of-state workers and businesses. The idea is good, the execution, a disaster. Courts have been too timid. The burden of proof is too high, and guess what? A landscaper or a welder doesn't have the time or money to hire a lawyer and fight state laws in court. We need Congress to step in and lead, not rely on broken courts to fix broken systems. Make no mistake, patriots, this is a class war. The wealthy and well-connected have every tool in the toolbox. They can lobby, litigate, and loophole their way to success. But working Americans? They're stuck behind paywalls, license fees, and red tape that's designed, yes, designed, to keep them down. Whether it's the small business trying to break into big tech, or the veteran spouse trying to keep her license, or the kid with a trade who's told he needs 1,500 hours of government-approved training just to cut hair, it's all the same game. control the people, limit opportunity, consolidate power. So what's the answer? First, we demand passage of the REINS Act and other legislation that puts lawmaking power back in Congress, where it belongs. Second, we need to dismantle crony regulations that serve corporations, not consumers. Third, we need licensing reform at both state and federal levels, especially for our military families and mobile workers. And finally, we need to expose and confront the alliance between big government and big business. This isn't about left versus right anymore. It's about freedom versus control. It's about we the people versus them the elites. So if you believe in the Constitution, if you believe that Americans should be free to compete, to work, to build something from nothing, then do me a favor. Smash that like button, hit that subscribe button for more no-nonsense truth. Drop a comment and tell me, have you or someone you know been blocked by government licensing or red tape? This is the fight for our economy. This is the fight for our country. And I promise you, I won't back down. Until next time, stay free, stay bold, and God bless the United States of America.